Hello and welcome everyone to the YouTube channel of SRIRAM IAS. My name is Pragya. So, in today's discussion we are starting with a new program in which we will be discussing important and current news about polity, as well as we will be covering the concepts that is involved in that news in very exhaustive manner. Polity, as you know, is a very scoring subject. What students generally do in their prelims exams, they do not understand the concept and hence they commit silly mistakes. So, the basic aim of starting this program is to make you aware about the concepts that are involved in the current news that is happening in the field of polity, so as you can avoid the silly mistakes in the subject of polity. The topic of our today's discussion is the money bill conundrum. See, money bill often remains in the news in one way or the other. Currently also it is in the news for certain reasons, because the Supreme Court is set to decide what constitutes a money bill. So, in this discussion we will be firstly studying about the background of our today's topic. Then we will be understanding what are money bills. Then we are also going to ponder upon the constitutional provisions. We are going to study the articles that deal with money bills and the legislative procedure related to the money bills. Then we are also going to discuss the important cases in the Honorable Supreme Court related to the money bills controversy. And then we are also going to understand money bills versus financial bills, and lastly we will ponder upon the controversy that is currently going on in relation to the money bills. So, let us begin with our discussion and understand the background of the present topic. So, if I talk about the background of our present topic, as I said, the Supreme Court is going to discuss the money bill, what constitutes the money bill. So, this case was referred from a 5-judge bench in November 2019. The 5-judge bench was led by the then CJI Ranjan Gogoi, and in the case law name was Robert Matthews. Robert Matthews versus South Indian Bank Limited. So, this case was before a constitutional bench, that is a 5-judges bench of the Honorable Supreme Court of India, and this case was referred to a larger bench of 7-judges bench that is yet to be constituted. And definitely this bench is going to be constituted very soon, and it will deal with a very important legal question which time and again comes before the Honorable Supreme Court of India, that what exactly constitutes your money bill? What constitutes the money bill? So, this legal question will be answered by the upcoming 7-judges bench that has to be constituted by the Honorable Supreme Court of India. Moving forward, let us discuss the moot point of our today's discussion. You might be thinking, ma'am is again saying and again money bill, money bill, money bill. So, what exactly are money bills? So, if I talk about a money bill, it is a part of the financial bill. It is a type of the financial bill. You might have heard that statements that all financial bills are not money bills, but all money bills are financial bills. Okay. So, it is a type of financial legislation that deals exclusively with 3 things. Firstly, the taxes. Secondly, the government revenues or expenditures. And thirdly, with the withdrawal or deposit of money in the consolidated fund of India or the contingency fund of India. So, all of this you will find where you will find under article 110 of the Indian Constitution. Okay. So it basically defines what is a money bill. So if I talk about the constitutional provisions regarding money bill, the first article is Article 109. This article is very special because it lays down the legislative procedure regarding the money bill. Okay, so basically it lays down the legislative procedure regarding the money bill. Now let us take a look at this article and understand its provision in details. So if I talk about Article 109, see, special provisions in respect of money bills. It states about special provision in respect of money bills. So basically a money bill shall not be introduced in the Council of State. What does it mean? That the money bill can only be introduced in the Lok Sabha. In the Lok Sabha. It cannot specifically be introduced in the Rajya Sabha. It is barred by section Article 109 clause 1. Okay. Then Article 109 clause 2 states that after a money bill has been passed by the Lok Sabha, Rajya Sabha gets just 14 days of time. Okay, in these 14 days it can either give it recommendations or it may not also give its recommendation. Now it completely depends on the Lok Sabha to accept the recommendations of the Rajya Sabha, and if it does not accept, the bill is deemed to be passed by both the houses in its original form. Okay, so the bill is deemed to be passed by both the houses in its original form. So it completely depends on the Lok Sabha whether to accept the recommendations that is given by the Rajya Sabha or whether to reject them. Okay, and if Rajya Sabha sits on the bill for 14 days and does not take any action, the bill is deemed to be passed by both the houses. If the House of the People accepts any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses with the amendments recommended by the Council of States and accepted by the House of People. So this procedure that is mentioned under Article 109 is very different from in the cases of ordinary bills, from the ordinary bills. See, in ordinary bills, what happens is it goes in 3 stages, stage 1, stage 2, stage 3 in both the houses. It can be originated in either house of the parliament, but what happens in the case of money bills, it can only be originated in the Lok Sabha, and the Lok Sabha has complete power over the money bill. It can either choose to act upon the recommendations or it can choose to reject the recommendations that is given by the Rajya Sabha, and if Rajya Sabha takes longer than 14 days, keeps on sitting on the bill, it is deemed that the money bill has been passed by both the houses of the parliament. Clause 4 states, if the House of the People does not accept any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the House of People without any of the amendments recommended by the Council of States. That is what I stated, that yes, now it will be deemed to be passed in its original form. Clause 5 states that if the money bill is passed by the House of the People and transmitted to the Council of States for its recommendations, is not returned to the House of People within the said period of 14 days. That is what I explained, that it will now be deemed to be passed by both the houses of the parliament. That means Rajya Sabha completely has no control over the passage of money bill, and that is why we say that money bill is a fast track legislation. And that is why in many of the cases the petitioner says that yes, now the government is using the money bill route to pass important legislation without any discussion in the Rajya Sabha. Okay. So this is creating a controversy which we will be discussing in our further slides. Now, if I talk about money bills, okay, so as I said, Article 110 of the Indian Constitution deals with the definition of money bills. So, a money bill will be called as a money bill only if it falls within any or one of the heads that are mentioned under Article 110, clause 1, subclause A to subclause G. That means it deals with the imposition, abolition, remission, alteration or regulation of any tax, the regulation of the borrowing of money or the giving of guarantee by the Government of India, or the amendment of the law with respect to any financial obligations undertaken or to be undertaken by the Government of India. So, basically government has borrowing powers, okay, and to maintain transparency and accountability, it is necessary that the government keeps a check on its borrowing power, and whenever government has to borrow something, it has to borrow it in the form of a money bill. The custody of the consolidated fund or the contingency fund of India, the payment of monies into the or withdrawal of monies from any such fund, the appropriation of monies out of the consolidated fund of India, and the declaring of any expenditure to be expenditure charged on the consolidated fund of India or the increasing of the amount of any such expenditure. See, there are various expenditures that are charged on the consolidated fund of India. For example, the salary of Supreme Court judges, the salary of President of India, so as to maintain their transparency and accountability. So, if the government wants to increases the salary of President of India, the salary of Supreme Court judges, then it will have to bring a money bill, because that will be declaring any expenditure to be expenditure charged on the consolidated fund of India. For example, a new post is created and that post receives its salary, and that salary is charged from the consolidated fund of India. Again, a money bill has to be passed. If an expenditure has to be increased and that expenditure is charged on the consolidated fund of India, then also you will have to require a money bill, passage of a money bill. Moving forward. The receipt of money on account of the consolidated fund of India or the public account of India, or the custody or issue of such money, or the audit of the accounts of the union or of a state, because it is very important to maintain the transparency and accountability of the government towards its taxes and borrowing, okay. That is why these provisions are considered, are there, that yes, these are money bills. So, they also help in maintaining the transparency and accountability of the Government of India or any of the state, okay. Any matter incidental to any of the matters specified in clauses A to F, and this matters incidental have been interpreted very broadly by the government, and that is why you can see so many legislations are now coming in the form of money bill. If I talk about certain legislations that have been passed as money bills, they include your very famous Aadhaar Act of 2016. If you talk about PMLA, that was also passed as a money bill. If you talk about FCRA, this legislation was also passed as a money bill. However, these legislation are in controversy as of now, because before the Honorable Supreme Court of India, various petitioners are arguing that these legislations do not contain any of the provisions that are mentioned in Article 110. So, how they were exactly passed as a money bill? Moving forward. I have already explained to you Article 110, it provides the definition of the money bill, and it also provides a very important clause that Speaker has the final power to decide whether a bill is a money bill or not. Where it has been provided under Article 110 clause 3 of the Indian Constitution. That means the Speaker is completely the final authority to decide whether a bill is a money bill or not, and that is why when a money bill is transmitted to the Council of State, it is already endorsed on that bill that yes, this bill is a money bill. Who endorses it? The Speaker has the power to endorse a bill as a money bill. And if you ask me what is a bill, Okay, because I am time and again using this phrase money bill. Money to is very clear, it relates to financial things. What is a bill? So see, bill is a very important instrument in the legislative parts of the government. Okay, it is a very important instrument in the legislative powers of the government. We all know that there are 3 organs of the government. Okay, so the government has 3 organs: the legislature, executive and the judiciary. The legislature, executive and the judiciary. Okay, and this is also known as often the doctrine of separation of powers. It is not as rigid as it is in USA, in India. Okay, so in India we do not put all of these functions in a watershed compartment, but yes, primarily a government has 3 main organs: the legislature, executive and the judiciary. So the primary function of the legislature is to make the laws. So how will it make a law? It will firstly enact a bill. And that is why I said that it is an instrument of legislative power of the government. Okay, so firstly it will promulgate a bill. Okay, it will enact a bill, and then that bill, if it is an ordinary bill, bills are also of 4 types, I should say. Firstly, ordinary bill. Secondly, finance bill. Thirdly, money bill, obviously. And the fourth one is constitutional amendment bill. See, as I said, money bill can only be originated in the Lok Sabha. Rajya Sabha does not have any power. Okay, if you talk about finance bill, then finance bill can be categorized as finance bill category 1 and category 2. So how category 1 is similar to money bill? Because both of these can only be originated in the Lok Sabha. We will be discussing it in our further slides when we will differentiate between a money bill and a finance bill. Okay. So broadly, bill is of 4 categories: ordinary bill, finance bill, money bill and constitutional amendment bill. So it goes through various readings: first reading, second reading, third reading, and then if it is not a finance bill, one or money bill, it goes to the Council of States. Okay, Council of States then decides. In the case of finance bill, in the case of money bill, it has no power to alter or amend the bill. Okay, the recommendations might be accepted by the Lok Sabha or might not be accepted by the Lok Sabha. But in the cases of ordinary bills, it generally goes through all the 3 stages in the Council of States or the Rajya Sabha. Okay, and when both the houses of the parliament passes the bill, and then when it receives the President's assent, it becomes an act, and that is how laws are made in India. So bill, if I say bill is an important instrument in the law making power of the parliament. It is the initiation of the law making. Firstly, a bill will be prepared, then it will be passed through 3 readings, then it will be passed to the Rajya Sabha, and then finally when it will receive the assent of the President, it becomes an act, it finally becomes a law. Okay. Proceeding further in our discussion, let us understand some of the important cases in the Supreme Court in relation to the money bills. So first case was the challenge to Aadhaar Act. Okay, the Aadhaar Act was challenged on the grounds Aadhaar Act controversy. So the petitioners in this case said that Aadhaar Act is not related to Article 110 of the Indian Constitution. However, the Supreme Court by a 4:1 majority ruled in the favor of government. Justice Ashok Bhushan, who wrote the majority opinion, opined that Aadhaar Act was money bill. Okay, why? Because it dealt with benefits and subsidiaries, and those benefits and subsidiaries were to be withdrawn from the Consolidated Fund of India. And that is why it fell within the ambit of Article 110, because the Aadhaar card was necessary to avail the subsidies and benefits which have to be withdrawn by the Consolidated Fund of India, and that is how it relates to Article 110. Okay, and that is why Aadhaar Act was a money bill. This was held by the majority of the judges in this case. The only dissenting opinion was of Justice D.Y. Chandrachud, presently who is now the Chief Justice of India, and he said that passage of Aadhaar Act as a money bill was a abuse of the process of constitution. Abuse of the process of constitution. So he gave his dissenting opinion that the Supreme Court should actually answer what constitutes a money bill. In this case, it was quite clear that yes, there is a confusion regarding this legal question, that what exactly constitutes a money bill. And then came the Finance Act of 2017. Most controversial provisions of Finance Act 2017 includes the electoral bond scheme, and then the tribunals. Okay, the control of tribunals by the government. So these were the controversial provisions of the Finance Act 2017. You know, in the electoral bond scheme, they have completely struck it down as unconstitutional, but still in the electoral bond scheme case also, the Supreme Court refrained to answer what constitutes a money bill, because the matter is already sub judice before a 7 judges bench of the Honorable Supreme Court of India, that is yet to be constituted. And then in the cases of tribunals also, the petitioners were arguing that struck down the Finance Act as whole as unconstitutional, but in that case also the Supreme Court didn't struck down Finance Act 2017 as a whole as unconstitutional, but yes, requested the Supreme Court to consider it by a larger bench that what exactly constitutes a money bill. Then since 2019, the courts have refrained from answering this question, you know, delving into this question that what exactly constitutes a money bill, because the matter is already sub judice before a 7 judge bench of the Honorable Supreme Court of India, that is yet to be constituted. So these were the important cases before the Honorable Supreme Court of India in relation to the money bill, and in each of the case the petitioners are constantly trying to argue that yes, the government is trying to bypass the legislative powers of the Rajya Sabha. By resorting to money bill legislations, by making the legislations pass as money bills. Okay, so this is the moot point of the discussion that is going on before the Honorable Supreme Court of India, the moot allegations that have been put by the petitioner in various cases. Moving forward, let us understand the differences between the money bill and finance bill. If you will ask me, ma'am, what is a finance bill? So basically it relates to revenue or expenditure. Okay, it relates to anything and everything apart from money bill, and that bill is known as finance bill. It is dealt under Article 117 of the Indian Constitution. If you talk about finance bill, it can be also categorized into two categories. First is your Finance Bill 1. And second is your Finance Bill 2. So, Finance Bill 1 deals with other matters that are financial in nature apart from the money bill. For example, a bill could contain a borrowing clause, but it might be possible that it is not dealing with borrowing. So, if you ask me the similarity between Finance Bill 1 and money bill, so they can both be introduced only in the Lok Sabha. And they can only be introduced after the President's recommendation. So, this is the similarity between Finance Bill 1 and Money Bill, that they can only be introduced in the Lok Sabha and they can only be introduced after the President has recommended the introduction of such bill. But in all the other cases, Finance Bill 1 is very similar to ordinary bill in if you talk about the legislative procedure. That means Rajya Sabha has the power over it, okay, and Rajya Sabha can make amendments or alter the provisions of Finance Bill 1. So, only in these two aspects it is similar to money bill, but in other aspect it follows the legislative procedure of an ordinary bill. Finance Bill 2 basically deals with the Consolidated Fund of India. But apart from those matters, that are mentioned under Article 110. So, Finance Bill 2 also follows the ordinary procedure of an ordinary bill, legislative procedure. In both the cases, if there is a disagreement between Lok Sabha and the Rajya Sabha, a joint sitting under Article 108 of the Indian Constitution can be called by the President of India. Remember that a joint sitting of both the houses cannot be called in the cases of money bill. Why? Because Lok Sabha has the complete control over the money bill. It is completely, free to not to accept any of the recommendations that are given by the Rajya Sabha. So, that is why there is no provision of joint sitting of both the houses. But if you talk about Finance Bill 1 and Finance Bill 2, yes, in case of disagreement between the Lok Sabha and the Rajya Sabha, a joint sitting under Article 108 can be called by the President. So, these are the major differences between a money bill and a finance bill. Let us discuss Article 117 of the Indian Constitution. See, it talks about the special provisions as to financial bill. A bill or amendment making provision for any of the matters specified in subclauses A to F of clause 1 of Article 110 shall not be introduced or moved except on the recommendation of the President, and a bill making such provision shall not be introduced in the Council of State. Why? Because it is termed as a money bill. That is what I have explained. Provided that no recommendation shall be required under this clause for moving of an amendment making provision for reduction or abolition of any tax, and hence this proviso becomes very important for you. If you want to reduce the tax or abolish a tax, President recommendation is not required. A bill or amendment shall not be deemed to make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. Exactly, this is talking about what is not a money bill. What is not a money bill? So, just because it provides fines, pecuniary penalties, it talks about abolition of taxes, inclusion of taxes by any local body or authority, will not make it as a money bill. Okay. So, this clause provides what is not a money bill. A bill which, if enacted and brought into operation, would involve expenditure from the consolidated fund of India, shall not be passed by either house of the parliament unless the president has recommended to that house the consideration of the bill. And this is talking about your finance bill 2. Okay, I said that yes, it deals with the consolidated fund of India. I said that yes, I explained to you that yes, finance bill 2 is very similar to an ordinary bill. The only thing is that it does not require the president recommendation at the stage of introduction, but yes, it cannot be finalized until and unless the president has asked the house to consider it. Okay, consider the bill. So, it basically requires the assent of the president at the consideration stage and not at the introduction stage. So, this was all about article 117 of the Indian Constitution. Now, let us talk about what exactly is the controversy that is going on. What is the money bill conundrum that is going on? So, government is taking the money bill route to pass various kind of legislations, and as the speaker has the final and complete authority to judge whether a bill is a money bill or not, it definitely bypasses the legislative powers of the Rajya Sabha. So, this is the main controversy. In Aadhaar Act, the Supreme Court has opined that yes, the judgment of the speaker can be subject to judicial scrutiny, but it is not necessary in every case that it will be subject to the judicial scrutiny. Only if it is proven that yes, prima facie there is a case, prima facie there is a mala fide intention, then only you can do judicial scrutiny. Otherwise, his decision is final as regards to whether a bill constitutes a money bill or not, and that is why the Supreme Court is all set to answer what constitutes a money bill. And definitely this legal question, once answered, can also pave the way for PMLA reconsideration, for the reconsideration of the Aadhaar judgment. Okay. Why? Because once the Supreme Court has clarified what constitutes a money bill, definitely those legislations will be open to challenge again. Let's see what happens, let's see what time tells us, because the 7 judges bench has not yet been constituted. What is your opinion in the case? Should money bill be used as a fast track legislation? Should parliament bypass the legislative powers of the Rajya Sabha? Kindly let me know in the comment section below. I hope this discussion was insightful for you. You gained something out of it, and be there with us every day for such insightful and fruitful discussions on the Indian polity, so that you can gain conceptual understanding and you can avoid silly mistakes in your examination. Thank you so much guys. Have a great day ahead.